Hi, good evening, and welcome to another edition of our Justice and Pieces guest speaker series. Today's guest is Joshua Shaw. He is a PhD student at Osgoode Hall Law School. And I was always loved the connection to Osgoode there. And as well, he is working in the legal process class there. So a lot to talk about in that regard. But first, Josh, maybe you can do a quick introduction there. I think, you've had a journey there across three provinces leading to your PhD studies. So maybe you can tell us a little bit about your time at law school and then articling, and as well, you got your master's before pursuing your PhD now at Osgoode.
Thank you. I'd be happy to. So yes, I'm from Manitoba originally. I did my undergrad and my law degree there. I graduated with my law degree in 2015. So it's been a few years since I graduated. And I very much enjoyed law school. I have a small cohort relative to the larger classes that I think are primarily had in Ontario law schools. So I recall having fond memories of my colleagues there. But I was very excited to leave the province at last once I graduated, and I articled in 2017. As you just indicated, that was the articling was the year after I did my Master of Laws after my Juris Doctor. And I articled at the Office of the Information and Privacy Commissioner of Ontario, where I subsequently worked for a few years after, until I couldn't do that and a PhD together anymore. And now I'm just a PhD candidate or student at Osgoode. So that's the trajectory. I went from Manitoba to Halifax, Nova Scotia, because I was doing my master's at Dalhousie University, and then have been in Toronto since 2016.
Now, what kind of drew you into, I guess, from obviously, you got your master's there in Dalhousie, and then you're looking to article. But were you looking towards Ontario? Was this kind of, the intellectual property there? Did that kind of in the Commission of Ontario? Did that kind of pop out to you, or was it just kind of coincidental that you ended up going to Ontario from Nova Scotia?
I certainly didn't have any grand design for my life. I was just going with what approximately achieved my interests in law, which were at that time primarily public law, and if possible, on the more policy end of legal practice. And even more narrowly than that, something dealing with public health law or policy. And thankfully, the Office of the Information and Privacy Commissioner of Ontario has jurisdiction over health privacy issues. So I was able to live out my desires, but that was all sort of by happenstance. I never really knew that I would end up in Ontario. I really didn't know where I would go after my Juris Doctor. I just knew that I wanted to do my master's. I had hopes to do academic work afterward, but I knew that I wanted to article and get my call to the bar in the event that that might be meaningful and useful in my career or life. So yes, again, no grand design at all. Just, I think, as with most law students or paralegal students, I'm sure as well, I cannot speak for that, but I imagine that there's a lot of uncertainty and you just sort of end up in places you never really fully expected. And there's nothing wrong with that. And I suppose I've learned to derive some pleasure from it.
Now, certainly, I mean, maybe you could talk a little bit about articling. Some of the law students here are into their third year, and next year will be their articles. Some of it has been secured. I guess some of it sometimes comes later. And I guess in your case, I'm presuming that you were doing your master's first, and then you went and gone through the whole articling process. So maybe you can share a bit of that, because there's always, even thinking back to my time, there's always that anxiety of securing articles, and then the experience itself. So maybe you can share a little bit about that for the students listening.
Absolutely. So I did apply to articling jobs while I was doing my Juris Doctor. I wanted from first year to go on and do my master's, but it's hard not to get caught up in the anxieties of your colleagues. And they were all applying, for summer positions and articling positions. So I thought I might as well do the same, even though I had at least the immediate goal of doing my master's after my Juris Doctor. So I did apply and I interviewed mostly public law and public interest related offices. I was very nervous. I was very afraid. And I think at the time I was a great nuisance to my then partner because I could not stop fixating on what I might do afterward. It may not be apparent on the Zoom, but I am notoriously, or maybe notoriously is too generous, but I'm a terrible public speaker. I could speak pretty well, I think, in the context of teaching, but I am a very nervous speaker. So I have tried to avoid all that. And I think it probably came across in many interviews that I completely bungled. I remember an interview in Newfoundland for an articling position that at the Department of Justice there, and I was just awful. There were so many mistakes that I made trying to figure out how to comport myself as a professional for the first time, since that wasn't really something I had much exposure to prior to law school. And I made a lot of mistakes and felt a lot of anxiety, but ultimately I resigned myself, although perhaps it was actually a happy result to just pursuing my master's first after my Juris Doctor, and re-entered with some encouragement from colleagues there, both at the Juris Doctor level at Dalhousie and also from my colleagues in the master's program at Dalhousie. And with the support of my supervisor, Jocelyn Downey, I felt much more invigorated then and confident that I would be able to land an articling job. And during my master's, I applied to one articling job. That was the Office of the Information Privacy Commissioner of Ontario, that very long name. And I succeeded in that first round. So again, picking up on a comment I said earlier, there's a lot of unanticipated, unexpected outcomes with one's journey. I'm a person who loves to have things rigid and scheduled. And that's not what life afforded me, and probably will not afford me going forward as well. And I've just had to adjust to it. As terrifying as it felt, as dark and as much as I despaired at many moments in my Juris Doctor, I ultimately have come to the other end and feel so much happier and content and am doing precisely what I wanted to do. It's just taken a slightly different direction and entailed a little bit of misery. If perhaps that might be overstating it, but certainly it's felt like that.
Well, I mean, in the end, I guess you got that position that you applied for there in Dalhousie. What was it like, working at the office there? Well, what were the kinds of things you did as a student, and then certainly in the years after? I think you stuck around there for a few years. I think simultaneously maybe doing your PhD, and we'll get to that decision in probably the next question. But what was it like articling and then working there afterwards?
So I very much enjoyed it. I wanted at that moment, whenever you take on the next task, I have a tendency to pour myself into it. So I was confident in that moment of articling that is where I wanted to remain, or at least in an adjacent office for a long portion of my life. I had designs to be a legislative counsel somewhere. So thankfully, a lot of the articling experience that I obtained there was directed towards the legislative ends of things. The Office of the Information and Privacy Commissioner of Ontario, I will now just refer to it as the IPC. The IPC is involved in providing a lot of comments and advice to other offices, both in government and non-government context, on privacy legislation specific to Ontario and on privacy policy and principles just more generally. So as an articling student, I was involved in a number of files relating to that. With respect to health privacy in particular, I remember working on a medically assisted dying related submission because after medically assisted death became legalized, there were subsequent forms of legislation that were important, especially provincially, to providing such a service. And privacy or access to information was implicated in that. So I remember being part of very exciting policy or legislative activities through the Office of the Information Privacy Commissioner of Ontario. And that carried on throughout most of my activity as an articling student. I was also involved in judicial reviews. Often individuals may be dissatisfied with the outcomes of our office's decisions. So I was involved in helping our litigation counsel with judicial review, even though I myself thankfully didn't have to be advocating in court. I was present after preparing the materials that the litigator would rely upon. And I also would provide advice with the guidance of my principal, of course, to the tribunal that's within our office. So that's what I was primarily involved in doing as an articling student, more legislative activities, policy activities, in various consultations that the office would be implicated in, and also the advocacy in terms of the administrative law issues and just the tribunal itself. I remained afterwards, I moved into the Department of Health Policy, and that's where I applied my legal services, or rather my legally trained activities, was to the application of policy. And so I drafted many submissions and documents in that context and participated in submission, either consultations with respect to submissions or consultations about activities that the government were participating in as a policy analyst in that capacity. So that's what I did for 2 years after my articling, with 1 year overlapping with the PhD. And I did enjoy the work. It was at that point, though, that I decided I really wanted to do legal theory a lot more seriously in a capacity that an administrative office or a government adjacent office would not allow. Even though many of my files, the memoranda I would write, the reports I would write, did allow me to engage in interesting concerns, bioethical, public health policy, various concerns that are of interest to me, dear to me, I wanted to perhaps have the benefit of academia where I get to do a little bit more of what I want to do. And that really motivated that transition. Yes, that's the kind of activity I did as a articling student at the IPC, and in the health policy department of the IPC, was primarily legislative activities or policy activities.
So then you find yourself, I guess, back into school there now, pursuing your PhD. I think that would have started in about 2018, I would think. So what kind, I mean, I guess we can talk about maybe, I think you're doing your thesis around the human remains. You could tell us a little bit about that, and then maybe we can go into the TAing right after. But what are you working on in terms of research there along those lines, and what are you hoping to finalize in, I guess, the next year? Hopefully, you'll be able to finish your PhD at Osgoode.
Yes, I don't have a fetish, but I am into law as it relates to human remains, and so I have a variety of different projects that look at law's relation to human remains, primarily with a legal theory focus. In fact, I would say virtually all my research output is now in legal theory or the social study of law. My dissertation is specifically looking at law relating to the classification of some remains as waste. Perhaps biomedical waste would be the easiest example to provide of that. And contrasting that to the classification of human remains as something that need to be buried or cremated or otherwise disposed of in a dignified manner. And so I am critically reassessing the legal doctrine, often property law, there could be environmental law, regulatory law, health law, that apply to human remains, and trying to assess how that classification is made. It's not an explicit classification between some remains as waste and non-waste, although there are some instances where it is a little bit more explicit, I suppose, but it's primarily an implicit one that I'm trying to pull out and analyze through legal theory. So I draw on critical legal theory primarily to think about how law makes that classification. And I think perhaps the unique contribution of my dissertation is to look at how human remains themselves, there are certain material aspects of the remains that are able to participate, have some sense of agency in the production of legal meaning and ordering specific to them. So that perhaps did not make too much sense, but the idea in a more general layperson's way of framing it is to look at how human remains may be a legal actor, even though they don't have a mind, even though they don't have those qualities that we typically associate with the legal person. In fact, in many respects, we don't think of human remains as being a person at all. I want to look at, in this instance of classifying some remains as waste and non-waste, how qualities of the human remains are able to participate in that classification. So I have some historical studies dealing with the early Canada or early dominions or colonies of Canada, looking at burial law reform, as well as looking at the UK in the 19th century. And then I have a much more contemporary example where I'm conducting interviews with individuals who've had body parts removed from them for a variety of different reasons, and the ambiguity that often comes with them wanting to hold on to those body parts. The law has a sort of an ambiguous status with respect to these remains or these body parts. And so I'm doing interviews with them, as well as looking at more textual documents, trying to understand those moments of classification. And then the last, I guess, case study of my dissertation is looking at human remains, often of those who are racialized or those who are otherwise marginalized, and looking at how they are rendered or treated as effectively disposable. So in a way that might approximate an understanding of those remains as waste. And so in that moment, in that movement, in that case study, I begin to draw upon critical race theory and post-colonial theory and use those forms of literatures to supplement and critique and improve the critical theory I've been working with elsewhere in my dissertation. So that's the kind of work that I am doing in my doctoral dissertation. I have been published in peer-reviewed journals on related matters of law and death, law and the body, critical disability studies in law. So those are the kind of things that animate me, and I continue to do that in a variety of side projects. I certainly don't have a dearth of research projects to work on. I keep taking on more and more, which is exciting. This is why I wanted to go back to academia, to go back and do my PhD, was to be involved in the generation of knowledge and ideally translate that into teaching or other pedagogical contexts. Anyway, that's where I'm at. You can, of course, ask me further questions that you may have, but that's what I'm doing.
Yes, let's talk a little bit more about the teaching there. I mean, you spent now a few years doing legal process. I think when I was at Osgoode, it was legal research and writing. So I'm presuming it's kind of, I think they took them together and put it, and I believe it's still probably Shelley Kierstead still kind of heading that up. So that speaks probably to her length and experience there. And I remember actually I had my TA on for that course about last year. And he recalled at the time, it was about 14 years later, but he would be doing it on a Friday morning. And it was always the most painstaking class to get up for in your first year after, Thursday nights used to be like the nights everyone would go out. So what was that? What's the experience like in legal process? Now, certainly I would think you've had some classes in person and you've had some classes over Zoom. What have you kind of experienced in doing that? And especially, as you said, not a public speaker by design, but how did you kind of get over all that and lead those sessions there with the students there on centered around writing and research?
So I have benefited from wonderful students over the past 4 years. I'm entering the fourth year of teaching as a TA in legal process. I've had wonderful students who've been very generous and patient with me, especially in that first year. I do a lot of preparation in anticipation of the tutorial, each tutorial, whether it's in person or over Zoom. My partner has to listen to me rehearse a lot. And I have a tendency to talk a lot and perhaps overly intensely when I have something that I really care about or something that I take great interest in. So in the context of teaching, especially in tutorials, my concerns with speaking are a little bit more easily overcome. I just have a overly pervasive sense of social anxiety, among other anxieties, that I've just never been able to quite shake. But with repeated exposure, not that I'm a subscriber to behavior modification, but with repeated exposure, I've been able to diminish the amount of fear, or at least diminish the degree to which it interferes substantially with my presentation. So that benefits from conference presentations, that benefits from the teaching that I've done over the many years. I've gradually become much more comfortable. Although with that said, I'm sure students see me pacing outside the classroom. Well, when it was in person, they would have seen me. This past year, they would not, but they would probably, they have seen me, I'm sure, pace around. Pacing seems to be a consistent way by which I manage my anxieties, both during class. It's something I do, which might be a distraction. I hope it's not to students in my class, but also in anticipation and afterward, of course, too, because I'm always going to ruminate. But for me, the way that I help manage this even further beyond these silly tricks is I very much care about teaching. I want students to learn the law, even in a more clinical oriented course like legal process. I think legal process is a very important course. As much as it pains people like you and others, it pains me at times too, but this is often the first time law students have ever been exposed to that which is unique to the legal system, that set of research skills and writing skills that service the legal system, the advancement of advocacy in legal courts or administrative tribunals or other settings. It's one that I think I could have benefited from a lot more when I was in my JD. I know that we had a research and writing course similarly set up, but I didn't either take it as seriously as I should have, or my recollection is very poor. I just don't remember taking enough out of it. I would have benefited from that because there is, to use a little academic terminology, there is a sense of habitus, sort of this unconscious or non-conscious influence that factors into how we comport ourselves, how we speak, how we present ourselves, that I think really matters in terms of how we feel comfortable in legal spaces, in the law school and otherwise. So I take these tutorials very seriously because I think that they're an important step to making students feel comfortable, even when they're failing in those first few months, when they're not necessarily failing literally, but when they feel that sense of failing, because this is all new to them. So I take that very seriously. I'm also in a setting with these students that is relatively small compared to the professors. Professors might have students of 100 law students because I think they typically divide the students into 3 sections for each year. Obviously, up-here courses will be smaller in the seminar kind of settings, but for first-year students, they're otherwise in very large groups. Professors don't necessarily have the chance to form close relations with the students, nor the students with the professors. So I am in a unique position where I'm able to assist the students beyond the tutorials themselves, to provide guidance, to connect them with my social network, my professional network. and to talk them down when they're feeling quite poorly about themselves, about their performance in other courses or otherwise. I think that this has been a really helpful ground for me for learning what pedagogically matters to me. And that is ultimately exposing students to new ideas, ensuring that those students feel comfortable, and ensuring that those students are surrounded by an intellectual community that will challenge them and hopefully further them. And I'm proud and happy to say that I maintain contact with many of my students afterwards. And even though I'm no longer teaching many of them, and probably will never be in a situation where I'll teach them again, I hope that I can still be of some value going forward. Anyway, that has been my experience of the legal process, which is a totally different way, I'm sure, of experiencing it than what it feels like for a student. But I hope that some of my excitement translates into the tutorial and into the classroom and outside of it.
So in terms of, I guess, the tutorials, you have like a portion there of the class. I think it's probably once a week that they have the tutorial, and then once a week they have kind of the main lecture there. So what kind of, in terms of getting, let's look at like the legal process itself. I know, in terms of research and starting, and I think that's why it's a very important course. And same thing I tell my paralegal students is, well, before you go and learn about, the different subject areas, or while you're learning about it in law school, because you're doing it simultaneously, well, you need to know kind of how to attack, if you're given a problem, to do some kind of research or to find in the law, or find common law, case law, whatever, on top of the statutory law, and kind of answer a question usually, right? I mean, when you go into practice, you're going to have a client that'll come and say, hey, do I need to, am I violating this Consumer Protection Act or whatever? I feel that there was some case like Voliak Automotive or something when I was taking that class. But what kind of is that process there? How do you kind of get to students, a couple weeks into the program at Osgoode, and kind of get them into thinking about attacking those kinds of questions? And what do you share with them kind of as you walk your way through the process? I know, even like the McGill guy has been updated, I think, a couple of times since I was in school, because I have to, like, oh, we don't have the periods anymore. But let's say, look at the first step in the legal process before we kind of move on into then looking at how to write and the legal steps there.
Mm-hmm. So the McGill Guide obviously is the least exciting part, and unfortunately it occupies a lot of our attention pedagogically in the early sessions of the tutorial. Thankfully, Dr. Kiersted tries to include other aspects alongside the McGill Guide, so we're not just boring the students with that guide. I think in a general sense, I try to help reinforce a certain approach to legal analysis that I think helps break it down in ways that I don't recall any professor teaching me in my first year. And so perhaps in a way I'm approximating what I've had to teach myself through law school and afterward. But I like to use the metaphor of the sausage casing. So I try to use this metaphor as a way of compelling the students to orient themselves to the law differently. I don't want them to think of the law, whether that is from the common law or whether that is in legislation. I don't want them to think of the law as just some sort of fixed principle. I want them to apply it in a way that will advance a certain sense of legal reasoning. And so the sausage metaphor is really to think of the facts of a legal matter. It could be some sort of social event, let's say a car crash, and to think of those facts as the innards of that sausage. And I try to compel my students to think of those facts only through their encounter with the sausage casing, which is legal principles. And their task as law students is to, and eventually lawyers, is to create these sausages. And eventually you get this chain of sausages. legal principles being merged with the facts of some sort of social event, some sort of event of legal interest. And that's how we need to present arguments either in written or oral form to either a court, to an administrative tribunal, to your board of directors, to whomever it is that needs to rely upon that legal knowledge. And the reason why I use this metaphor is I'm trying to get them to think of these facts not in their ordinary non-legal senses. I want them to think of those facts as legal facts, but in order to obtain that transduction from the non-legal to the legal, there is a way of framing, an active cognitive framing that we need to carry out. And so that's why I use this metaphor, hopefully to instill in them and to keep it in their mind, because we're not otherwise talking about sausages in law school, to get them to always encounter whatever legal event or social event of interest is, and always encounter it in these legal principles. And the case law, the analogous case law, the case law that is distinguishable, that might discourage us from reaching some conclusion, these are all adding or taking away from that sausage casing. And so in using such devices, I hope I'm able to assist these students and maybe breaking through something that can otherwise be quite mystifying. I don't know if it works. I certainly have received positive feedback from students, so I hope that it is making some sense. I also reiterate it consistently throughout, adapting it to the different settings of advocacy, whether written or oral, that we undertake in our tutorials. So I hope that over time they get a better appreciation of what is distinct about a legal method, and that it is sort of a pragmatic exercise of presenting arguments to a particular audience that has sort of received norms, received principles, received institutional ideas that they behave under, more or less. And that exercise is distinct, I think, from other forms of social inquiry or knowledge production that don't have to concern themselves with the legal system.
Now maybe let's look on to the writing part then, right? So once you kind of done your research and you're ready to go and write, what have you noticed, I think, in over the last 3-4 years there, in terms of, you know, the different I'm assuming they would have some kind of memo that they'd have to create at some point. What are like the do's and don'ts maybe you can share for students in terms of their writing that you've seen in your experience as in heading up these tutorials? Maybe you can share from that experience with us.
I will try my best, but keep in mind it's been a while since I've had to evaluate the memos that I do every year. But I think crucially, it is about that legal analysis. And unfortunately, that's the thing that a lot of students struggle with. So this comment applies more broadly than the memos, but I think the memos is one of the first situations where these students are faced with what is distinct about the legal method or the legal analysis. So again, I try to ensure that students follow what we teach, that CREAC method, which is perhaps an alternative way of framing or phrasing the sausage casing metaphor. So to always lead with that conclusion, to have an identification of the rule, and that might be with respect of the case law or legislation, statute or regulation, or wherever else that rule might emerge. Then an explanation of that rule, relying upon authoritative case law, keeping in mind, of course, the jurisdiction, notions of precedent, what is binding, what is not, what is authoritative, what is not. An application, and I think application is where we see the struggle. We see the difficulty for students in setting out the legal principle in relation to the facts and reinforcing it with reference to analogous case law or other sources of law, or distinguishing with reference to other case law or other sources of law. It's the application I think students struggle the most in. And certainly that's where I'm most concerned, because I think if I make an early intervention, I might be able to assist them not only with that memo and any future memos that they write, but any future task like exams that they have in other courses that involve legal analysis. So I always try to remind students, again, with reference to the sausage casing metaphor, that you really want to always, whenever you're articulating about a fact or articulating something about a fact, you want to tie it back to a legal principle, and vice versa. Every legal principle that you articulate in the context of the application has to always be related back to these facts. You can't just sort of in a bare manner, in a bald manner rather, present a legal principle, because that's not of assistance to the legal actor, whether that's your principal or that's a court in the context of other forms of advocacy. The legal actor isn't interested in that bare principle or rule, that baldly stated principle or rule. They need to know how that principle or rule should apply to the facts. So merging that, and that is, again, the distinctive exercise that I try so hard to instill in my students, merging the principle with the fact so that you are always presenting the audience with the sausage or string of sausages. That's important. And the conclusion, again, another conclusion at the end of each point, so that you sort of tie up that sausage and so it doesn't unfurl and you lose all the contents, you lose the reader's attention. You want to make sure it's nice and discreet and packaged. Other points I want to raise is, I think simple writing is often better. I joke because my own academic writing is very verbose, it's very flowery. I love writing in that manner, but it's perhaps a little bit more acceptable in such a setting. The audience that will be reading your memos, the audience that will be reading your written advocacy or hearing your oral advocacy, they need these complex legal principles relating to these complex facts to be communicated in the clearest and most comprehensible manner. And so avoiding unnecessary flourishes, I think, is ultimately going to lead to better advocacy for the law student and other individuals who are involved in legal practice, like paralegals. I think that this can be hard because for a lot of law students in their first year, they're still just trying on the appearance of a lawyer, and they don't know yet what it actually entails, what is distinct about the legal method that they're learning. They're still figuring that out. And again, it's not something that can be maybe easily verbally taught. It is more of a habitus. It's sort of a non-conscious thing that you need to get them to feel, or at least that's what I experienced myself, and that's what I try to relay to my students. So I think for a lot of students, because they're just putting on the appearance, they're still struggling through their first few weeks, first few months of law school. They try to dress up their assignments with language that they think sounds legal, or sentences that they think sound more authoritative, when they ultimately belie any sense of authority, any sense of skill. And what ultimately will serve a lawyer, regardless of where they practice or how they practice, whether it's in a conventional legal setting or whether it's in a non-conventional legal setting and you're providing legal advice or legal analysis in some other form, it is about communicating in a clear manner and in a manner that behaves according to the norms and principles of that legal system. In a way, I think all this that I'm rambling about, and hopefully it's making some sense as it comes out, all of this is about getting the student to appreciate that there's a certain role relationship that they have to the institutions that uphold and create law and legal meaning. And so keeping attentive to the legal audience, whether that's the court, whether that's your principal, being attentive to what are the best ways of constructing an argument that will convince them, is what I am trying to do in my teaching, including in this memo. I perhaps have overstepped or gone beyond the question, but I hope that's somewhat coherent for you, John Paul.
No, I mean, although every time I hear law school and sausage, I think of the time Osgood students organized like a hot dog eating contest, and I didn't do so quite well, and I felt definitely sick afterwards. But
I'm
I
sorry,
think
I'll
it's a
stop
great,
the metaphor.
I think it's a great analogy there to kind of connect. Obviously, you got to finish off the conclusion and move on to the next point. But I mean, anything more in terms of, I mean, I think that certainly that's you get into law school and you think, hey, I need to sound more like a law student, and that's why you kind of dress it up with those words, and often that takes away from your point, right? Is that you need to kind of stick to the point and emphasize that. Anything else you find that would really help students improve on their legal writing, in terms of anything that certainly, because you can apply that to a number of the the exams you're going to do in other courses, or even all those, as you mentioned, certainly like if you're writing essays there, that's where you can kind of bring that out a little bit more, right, in a thesis. But in terms of more legal based writing, where you're doing memos and certainly providing advice in the future, what else can you share kind of from that legal process course that I think could be very valuable for students listening?
So I believe that something that I hope is encouraged, and I think students do this already, but I just want to reinforce it, that sharing one's work with others is really important. So unless, of course, the assignment requires secrecy or does not allow for groups to comment on each other's work, I do think that group work is a really important way of learning. And I think this is true of our writing exercises. Again, I'm not encouraging plagiarism. That's not what I'm encouraging here. But the reality is that once we're in law offices or in any professional office after graduating from law school, a lot of law or lawyering is group work. It's working with a principal, it's working with fellow associates. Even if you're not assigned to the same task, you might go to your colleagues and ask for advice. And I think that seeing how they're writing, hearing their comments about your writing, as fearful as you may be in sharing your work, I think that this can be a really helpful exercise. Because there's only so much that a teacher can do in the context of a tutorial or a classroom. So I think that working with your colleagues, learning from interacting with your colleagues is an important skill that will better one's writing and will hopefully allow you to see different ways, especially in those early moments of your learning in law school. Hopefully will open up your eyes and ears and all other senses to other ways of understanding the law. That there are different takes that one might want to reasonably take with respect to the law. And you may not otherwise readily see that and understand it until you read other people's work. And not only the work in case law or other professionals' work, but just the work of your colleagues. I don't know, again, if that's what you were looking for, John Paul, but that's something I would certainly want to encourage students, because I think sometimes there's a tendency to silo oneself. And that's always, I think, a detrimental thing for graduate students like myself in academia, and also for those who are doing legal practice.
Now, do they still have like a moot in the legal process class itself? And how
They
does that go?
do.
What do you share with the students there, especially the ones who are probably like yourself? Like, I don't want to be delivering these, and how does that kind of go? And I remember, I vaguely remember doing that in class all those years ago, but I think then it goes into like if you want to do like the learner's mood or something like that. But what do you share with students? And again, I do have some students who are going to go compete in a mood and things like that, about taking those, taking their analysis and now delivering it orally, and try to captivate and be ready to answer questions and things like that.
So it's a different type of advocacy, of course. So it entails a different way of communicating. And of course, those who have litigation experience and who practice litigation surely provide much better information advice than me. And so I'm always trying to find students other resources to help them, because certainly I am not a litigator. But in observing, shadowing, and preparing the advocacy documents, and then watching, I think I have some sense of how this should be carried out. So it is a different form of advocacy. It isn't the place, I think it's fair to say, to go into the same degree of detail of your written advocacy. It is a place where you're really wanting to assist the decision maker. You're there primarily for the benefit of decision maker as an officer of the court, although obviously you're trying to advance the interests of your client as well. But the idea is that you're there to assist the decision maker, and the decision maker may have questions, and those largely are more legitimate to address and answer than any prepared speech you may have devised over the weeks leading up to the moot exercise. So I try to encourage my students to understand that, to be ready for the fact that the judges in these moot exercises will be asking questions. They will often not be asking questions in the exact order that the students have prepared their submissions, and that they need to find a helpful way to adapt to that. I also, again, try to encourage students to think through the application of legal analysis to ensure that the legal principles are always being brought back to facts, so that you're merging legal principle with the facts. And this is hard to do in an oral setting because it's different than the written form that they've been learning so far in the course. So students struggle, but I provide feedback, very extensive written feedback to each of my students afterward. It's often a page and a half of written comments, trying to show them, trying to explain to them, individualizing it to their performance, and highlight aspects of their argument that very effectively brought those legal principles to the facts, that properly concluded it, tying up that sausage and leaving it for the audience member, the decision maker, to chew on. So these are things that I do to try and facilitate and encourage effective mooting. I think ultimately, I also try to remind them that this is, as much as it is a natural part of law school, it is a very normal thing to do, and you're going to do poorly at it generally. You're not going to feel good generally when you're doing it. And that's okay. Like, I felt terrible when I did it. And I try to find things in each of those students' performances that are indicative of their promise. Because I don't want them to think of that poor performance because it's often the first time they've ever done it, any oral advocacy. I don't want them to internalize that and to eternalize it, to think that that is forever how they will perform. Some people are able to work at things and improve as oral advocates or as public speakers or speakers generally. I think in some way I can be a testament to that I've worked hard at being able to speak more clearly. And I have tricks to do so. And again, repeated exposure helps. But there's, I think, generally a lot of potential in almost every student. And I want to highlight that for every student. So the mooting exercise that we do in the course is low stakes. It's there for them to wet their feet. And it gives me a chance to see where they may be struggling, either just that day or just struggling generally. And I try to reorient them and connect them with people who might be able to help them going forward. So that's, I think, how I approach it. But I have to keep in mind, and I try to be clear about this with my students, is that I'm not a litigator. I have never been one and will never be one, I'm sure. And that's a necessary qualification, not only for the advice that I give and the teaching I give, and the necessity to look elsewhere and to find other sources, books and other people to ready themselves for moot exercises, but also to highlight that it's okay that if this isn't your cup of tea, that there are other things that you can do. And my end of things was primarily policy driven or directed towards legislation, commenting on legislation or drafting at the very least, the policy language that would motivate or instrumentalize the legislation. So yeah, I think that's something I try to do and legitimize.
Perfect. So now, thank you so much, Joshua, for taking the time and sharing all of that, as well as your background and what you're writing about and your journey there from Manitoba to Nova Scotia to Ontario. And I just wanted to wish you all the best with finishing off your PhD. And as well, I know you're picking up a course there as well in Windsor this year. That's going to be something unique there for you in jurisprudence. So I wonder if you can close with any final words of wisdom for any of the students maybe you've had or any students you're going to have later this year in terms of, how best to kind of prepare for the, the legal process there, as well as beyond and into the rest of law school, and certainly in the legal field afterwards. And thanks again for joining us.
No worries. I think what I want to encourage students who might be joining a law school or a paralegal school or any equivalent form of training, I want to encourage them to relax as much as possible in advance of law school. Secondly, I want to encourage law students and paralegals and others that there are other paths. You don't have to be the conventional stereotype of a lawyer or a paralegal in a particular office. There are so many different applications of legal knowledge, legal training. I did that with my policy work, and I will continue to do that with my academic work, and hopefully that will continue as an academic. But even if it doesn't work, I'm open to the possibility of returning to policy lawyering or policy work. So that's a second point. And I think the third point, which is related, is just that there are so many contingencies. There will be so many moments where you will feel alone, afraid, uncertain, but that ultimately, generally, things work out for us. And if you are struggling with the work, with your mental health, with anything, I think it's important to reach out to peers, to mentors. That might be me, that might be your TA, that might be your professor, that might be your colleagues, that might be family. You reach out to people, and people can assist you in that moment of crisis, but also we can assist you with finding a future, figuring out what might work for you going forward, whether that is the conventional legal career that you've been dreaming of since you were 6, perhaps. That was certainly not me, but that might be you. Or it might be some other path. There's so much to law that I don't think we fully appreciate as young or not so young people just entering legal education. And I think it's important to anticipate that you won't be able to anticipate everything. And it's okay. You will be okay. I'm okay. And I would love to ensure that you're okay. And if I personally can't do that, I hope you have people in your life who will be able to ensure that. And I'll leave it there.
Perfect. So thanks again, Joshua. And again, all the best with everything there with you. And thanks for taking the time to join us. And thanks for everyone for tuning in. And hopefully those catching this a little bit later as well. And take care and have a great rest of the week. Bye, everyone.
Take care.